So we are covering every morning the progression of these cases against the state's gun ban because, listen, I mean, if there was a law limiting individuals' free speech to the level of saying that commonly spoken words can't be spoken until somebody registers that with the state, we would be definitely talking about it extensively. In the Second Amendment, you've got people challenging this semi-automatic weapons ban and the magazine ban, saying that it is indeed going after commonly held items that are, they say, protected in the Second Amendment. And of course, we'll be covering this as it progresses all throughout. Just in a few moments, we're going to talk with the Illinois State Rifle Association's Executive Director, Richard Pearson. But you can also call in live and local at any time, 217-629-7970. That's the phone number here where you can sound off on these issues. Again, 217-629-7970. But before we do connect with Richard Pearson, just to get some of the latest here and what to expect moving forward and maybe how some of you out there can help, they issued this statement yesterday about the filing of a preliminary injunction. And I went through some of the injunction and some of the original case and just wanted to highlight how they're looking at this and how they're going to advance forward. And it says in the initial case that they filed last week, while plaintiffs acknowledge that their sought result is contrary to one particular case, and even in Highland Park, another particular case, those cases have been abrogated by New York State Rifle and Pistol Association. Bruin case. In particular, they write, Bruin displaced Friedman's inquiry into Second Amendment cases into whether a regulation bans weapons that were in common use at the time of ratification or those that are some reasonable relationship to the prevention or efficiency of well-regulated militia and whether law-abiding citizens retain adequate means of self-defense. It goes on to talk about Bruin's replacement test. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation. So it'll be interesting to see how that ultimately is debated in the courts. But when you get further on, you start seeing some of the other things that they're looking to do. Of course, they're wanting the courts to declare that there's a deprivation of the plaintiff's rights in the law and a deprivation of the rights of the Second Amendment and 14th Amendment to the U.S. Constitution. But then you get into the preliminary injunction, and they're looking for the injunction to be granted from the federal court, the Southern District. They are saying that plaintiffs are likely to succeed in the merits because of the firearm ban is unconstitutional under Bruin. And they say the U.S. Supreme Court in that Bruin case held that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, as we said earlier. So what does all this mean? How is it going to advance? And how are they arguing that, you've got only certain types of weapons can be banned, including dangerous and unusual weapons can be banned? So that's another argument that the State Rifle Association is saying. They say if the ban is to survive, Illinois must prove that it's consistent with the nation's historical tradition of firearm regulation. It goes on further to talk about how the banned firearms in Illinois' law are in common use. They say the case thus reduces to the following straightforward inquiry. Are the arms banned by Illinois in common use, according to the lawful choices by contemporary Americans? They unquestionably are. The request for the federal courts is to determine, and that request coming from the Illinois State Rifle Association as well. They say that the magazine ban is also unconstitutional under Bruin. So those are some of the things that they're picking out here in the State Rifle Association's case, and we'll talk with Richard Pearson coming up in just moments. But first, let's get a phone call from you out there, 217-629-7970. Good morning. You're on WMAY.
Good morning, Greg.
Hey.
So, Bruin, couldn't that also, I guess, in a roundabout way, override the fire owner's identification card as well?
Yeah, but you gotta understand here, that's not what's being debated in the courts. And listen, I totally get where you're coming from, trying to pick apart all other things. The courts are already dealing with the FOID card issue. Whether it gets all the way to the Supreme Court, not sure. But that's a totally separate issue from what's being debated in the courts right now.
Okay. Hey, Greg, one more thing. I sent you something on Twitter last night. Mr. James O'Keefe has done it again.
Yeah, it's about Pfizer. Gosh, you know what? I've got to take a look at it. I have yet to delve into that. It's definitely something I'm interested in, and we'll see if we can unpack that maybe tomorrow if we get some time. I appreciate the call. Got to take a break and then come back and be joined by Richard Pearson from the Illinois State Rifle Association. A well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. That's the text of the Second Amendment. I might have one or two words wrong there, but in essence, the right to keep and bear arms shall not be infringed. Obviously, that's something that is being challenged by a law that Governor J.B. Pritzker enacted earlier this month. On January 10th, late in the evening, he signed that. It was the final day of the previous General Assembly, where lawmakers passed a bill that was at first a standalone bill, newly filed, but then they took another bill about amusement rides, gutted that, tried passing that, and then they took a third bill about insurance, and then they gutted that and passed that in the final days with amendments that were very last minute, changing a variety of things. But ultimately, the outcome has been the state banned the sale of certain semi-automatic weapons, 170 plus of those weapons, and it increases even more when you talk about what kinds of attachments can go on there, or what kinds of sheaths on the barrel, or what kind of magazine attachments there could be. And then you also have the prospect of the Illinois State Police adding to that list each and every year. So is that going to be thoroughly explored? But you also have the prohibition of possession and sale of certain magazine capacities, more than 10 rounds for rifles, more than 15 rounds for handguns. And don't forget about that gun registry, which if this is not struck down by the courts, then Illinois citizens could face a Class 2 felony if they don't register certain semi-automatic guns that the Illinois State Police deems are called assault weapons. So all of this, of course, being challenged. To my count, there are 7 different lawsuits. There are 3 in state courts I'm aware of, 2 from attorney Thomas DeVore. 1 has a temporary restraining order issued against the state from enforcing it on 866 people. A second case from DeVore that had an emergency hearing yesterday. That is going to possibly lead to a ruling on a temporary restraining order at any moment. So there are 3 different cases. Another one's in Crawford County, and I have yet to see an update on that. But then there's also 3 different cases filed in federal court that I've got on my radar. One of them is from the National Shooting Sports Foundation. I think the NRA is somewhat part of that. You've got a second one from Illinois Gun Rights Alliance. They're expected to file actually more additional litigation because the first one is just about the gun ban. They're looking to possibly do something about the magazine ban. And then also you've got a third one they're looking at possibly dealing with manufacturing of parts. But the Illinois State Rifle Association has a separate case that they filed in state court, and they've got their judge, and they filed yesterday a preliminary injunction request. And joining us now to talk about that is Illinois State Rifle Association's Executive Director, Richard Pearson. Richard, there's a lot of moving pieces here. What's the ultimate goal? While you guys aren't all working together across the state and federal court cases, what is that ultimate goal here in challenging this law?
Well, the ultimate goal, of course, is to strike the law down as unconstitutional. And everyone believes it is, except the people who voted for it and the governor. But so that's why we went after the temporary restraining order yesterday. You have to wait till all plaintiffs are served. They were all served yesterday, and so we filed yesterday. And so they have about 14 days to respond. But I don't know if they include weekends in those 14 days or not.
So when we ultimately get that response, is that when a judge will schedule a hearing and hear all the arguments, and then could they determine then that preliminary injunction is going to be granted?
They could. That's what we're working toward as fast as we possibly can right now.
We're talking with Richard Pearson. He is with the Illinois State Rifle Association, and talk a bit about, I guess, resource coordination. That's obviously a very important factor in this, as you've got these lawsuits costing quite a bit because having high-class attorneys to go all the way to the U.S. Supreme Court, that's not a cheap endeavor. But you've got the Second Amendment community in Illinois seemingly kind of spread out from all of these different cases, either paying DeVore to get individual temporary restraining orders, or gun groups like Gun Save Life with their lawsuits. And how do we best coordinate all of those resources across the state among the Second Amendment community?
Well, I would imagine at some point the judge will combine cases. I think that's really where this is all going to go. And so we'll see what happens at that time. But in the meantime, we'll press forward with our case. Our case is different from some of the ones in state court. Our case covers every gun owner in Illinois. So that's an important distinction. So the other 866, for example, those people had their rights restored, but it doesn't apply to everyone. And so our case applies to everyone.
Richard Pearson with us, Illinois State Rifle Association. You can find out more about the ISRA at isra.org. And, of course, you guys have a donate button there to help coordinate and finance the ongoing litigation here. Talk a bit about the importance of getting this preliminary injunction in place, because, as you said, the federal courts could possibly combine all these different cases that there are, and then you got filings of briefs and you got the summonses, and it just takes time to get all that together. How important is it that the preliminary injunction be issued while the court gets all of this wrangling together, right?
Well, right. We want to get all this stuff stopped. And so a preliminary injunction will do that. Then we'll have a hearing for a permanent injunction against this law, which will essentially declare it unconstitutional. We believe that, of course, the state will appeal this, and whichever suit they pick, and it will go up to the Seventh Circuit, which is the circuit we are in, and then the next step would be the United States Supreme Court.
And something that could take months upon months. Do you think all this is going to be cleared up before that January 1st, 2024 deadline for individuals to register their firearms with Illinois State Police or face that Class 2 felony?
Well, I believe that it will be. Actually, it starts the registration part starts the 1st of October.
Right.
So you have to. So we don't have a lot of time, and of course, they didn't want to give us a lot of time. So that was part of the plan. But so we have to get this moving fast. But if we get a temporary restraining order, then that stops everything and gives us time to argue for a permanent restraining order. And I'm sure there'll be a lot of legal maneuvering in that time after that is done.
Richard, yesterday the Illinois Senate was in, and I was able to get in front of a handful of the Senate Democrats that either were listed as not voting on the gun ban or voting no on the gun ban. And of the, I want to say, 6 or so different Democrat state lawmakers I reached out to who voted against it or were listed as not voting, some said that they weren't even in town that day. They didn't want to go on record saying that necessarily, but I only got one individual to respond on record, and we'll hear this later on in the show. State Senator Dave Kaler from Peoria, he was listed as not voting. What does it say that the Democrats that I approached just to get 1 minute for them to explain their no vote, they weren't willing to do that on camera or in front of a microphone?
Well, there's tremendous pressure by their own caucus on the downstate Democrats. Because they don't agree with all the things that the Chicago Democrats want to do. So we have a split there in the Democrat Party, and so that's something they have to deal with. But not everybody believes that this law is a good one. They were actually the legislators, many were bullied into it, and into voting for it, I should say. And so they're not happy with this. It wasn't a clearly vetted law. We were never invited to put any input on the law, nor was any other gun group that I know of. So this was simply a power grab by the Democrat caucus in the state of Illinois.
Richard Pearson, greatly appreciate your time as always. We'll definitely be talking again in the near future as this thing progresses, and we'll be watching for when the court date is set for that preliminary injunction that you filed yesterday, and we'll follow it all the way through to the Illinois Supreme Court and beyond. Greatly appreciate your time. Be safe out there, all right?
All right. Thank you. Bye-bye.
It is Springfield's Morning News now at